Hi, everyone. It's Kenya Rockmont, founder and author of the Child Support Hustle and the Reform Child Support Now movement. If you're joining me, I want to discuss the Turner versus Rogers decision this evening and the letter that our Attorney General Sessions rescinded about a week or so ago. I discussed it about 2 weeks ago, and the ACLU and a couple other writers released articles discussing him rescinding the letter that I discussed. So I wanted to prepare something for you all about what was in that letter, because even though he rescinded the letter, he couldn't take back all of the case law that was in the letter that was cited in reference to due process in child support cases. So I prepared some slides. I'm gonna see if I can upload them while get some more people in if they come. If not, people can always come back and view. I think it's important information if you have a case, if you're being threatened with arrest. I think this information is really crucial. So let me see. If I can't upload the slides while I'm live, I will do it right after. It's about 6 slides, and I just went through and detailed what I'm going to discuss as far as this landmark case that took place in, well, the case is out of South Carolina, but as I said, it went to the Supreme Court in 2011. June 20th, 2011 was the exact day. It doesn't look like I can upload. Shoot. I really want, well, I'm going to upload the slides. I can't do them now, unfortunately. I wanted you guys to be able to follow along as I went through this stuff, but that's okay. I'll post them afterwards. I'm gonna give a couple more minutes. We don't need a lot of people. We just need enough and people to share it, because even though he rescinded that letter, and I'm pretty upset about it, as I'm sure a lot of people are. Oh shoot, what did I do? We still have to, fight back. Hey Nate, hey, is it Karina? Thanks for joining me, guys. I'm gonna learn this computer stuff one day so I can know how to do all of this stuff, but not any day soon. Okay, I'm gonna start off with this Turner versus Rogers decision, and the slides that I prepared for you guys, I'll put them in, like I said, I'll put them in the comments, or I might just go in and post them as pictures. It's about 7 slides, and it has an outline of everything on here, what I'm about to discuss. I'm not going to discuss every piece of it because there's a lot of information here, but I want to go over the crucial stuff. If you're facing jail, and I'm not even going into, because Turner versus Rogers didn't deal with the license suspensions and things like that the letter discussed. This is specifically for incarceration and due process. So that's specific to this case. Okay, and I wanted to say something really quick before I got started, but I forgot what it was. It's old age. Okay, so the case of Turner versus Rogers. Turner is the non-custodial parent. He was ordered to pay $51.73 per week. He was held in contempt 5 times. The first 4 times he was sentenced to 90 days of imprisonment. He paid twice without being jailed, and he paid twice after jailed. So he paid the purge amount and was released. On the 5th time, he was sent to jail for 6 months. I call that prison, but you know. And upon his release, the family clerk of courts issued a show cause for arrears of $5,728.26. How could he pay the $6,000 because he was in jail for 6 months? And all this is all about him not being able to pay because he couldn't afford to pay. I'm not sure, Adam. I'm just going by what the source I'm referencing here is from the Federal Child Support Enforcement Agency. This is I got the notes from there, and on the slides that I'll post for you guys, I have the link there, and I also have a link that they posted because they reference programs that states are supposed to have implemented to try to curb the sending people to jail that can't pay. They're supposed to have like programs and things like that, jobs programs that they're supposed to offer before jail is an option or handed down as a sentence. Okay, so neither party had an attorney, Turner or Rogers. So the judge found that Turner was willful in contempt and sentenced him to a year in prison on that after he was released a 5th time. So he didn't get a hearing to determine his ability to pay, which is common. We all know that. And so he sued him pretty much after his release. After he did his year, they sentenced him to a year. The South Carolina Supreme Court rejected his claim that he was entitled to counsel, but the United States Supreme Court came back, and this is what I want to talk to you guys about. They overturned that, and they said the court violates due process when it finds a parent in civil contempt and jails a parent for failure to pay child support without first inquiring into a parent's ability to pay. Let's see, check out the page, Amber. Thanks, Adam. So if you don't know, which I didn't know until I got into all of this, the 14th Amendment's due clause, it doesn't automatically require the state to provide counsel in civil contempt cases. However, if jail is a possible sentence for you being held in contempt, you do have a right to an attorney. They are supposed to give you a lawyer. So that's just a side note. Okay. So the states after this is some of the information that came out after Turner versus Rogers. The Supreme Court found that the states must provide alternative procedural safeguards equivalent and adequate to notice of importance to the ability to pay. They have to provide the non-custodial parent a fair opportunity to present and dispute relevant info to express court findings as to the supporting parent's ability to comply with the order. So before they can issue those warrants and all that kind of stuff and these roundups, I post them a lot. I'll post them, the news articles where they have these roundups and they've arrested 70 parents or what have you. And there's nothing ever mentioned of these parents having a hearing to determine whether they could afford whatever this arrearage amount is. Their due process rights are being violated. They're supposed to have these hearings. And this ruling, as I said at the beginning of this video, this was ruled upon by the Supreme Court in 2011. So they've been violating this all these years, even though if you watch my videos or read any of my writings or anything like that, I don't think the child support system is legal or constitutional at all. But in combating the system and trying to try to get some kind of justice while we fight for reform, I found the best way to help parents is to fight them, combat them with their own guidelines. I can't call them laws because I don't recognize the laws that they put out, because it just violates the Constitution. So the best way that I've learned is to call them out on their, excuse my language, bullshit, by knowing what the guidelines are and saying, you didn't do this, and in this case, you didn't give me a hearing to determine I was laid off from my job. I haven't worked for 5 months. I've been actively seeking employment. I can't get a job because you guys locked me up, and now I have a felony, and I'm not willfully failing to pay support. I just can't get a job. You haven't broken the law, so legally they shouldn't be arresting you. I have a big problem with that. So that's why I'm doing this video, and that's why I fight so hard for reform. So I'm sorry I got off track there. Forgive me. So the Supreme Court found that Turner's rights were violated because of the following reasons. I'm sorry, you guys, my dog, if you hear her crying, you always hear if I do a video. They found because, excuse me, he didn't receive counsel or the benefit of the alternative procedures, which included the 2 procedures that I mentioned before, the safeguards. And again, I'll have it on the slide that I'll have for you guys. He did not have clear notice that his ability to pay would constitute the critical question in his civil contempt proceedings. No one providing him with a form or equivalent designed to elicit information about his financial circumstances. That's key. Before these officers, I can't call them, they're not judges, they're child support enforcement, they're like caseworkers. Before they can even initiate these the paperwork to get you arrested because you didn't pay your child support or whatever, they have to give you a form to fill out, pretty much. I mean, it's right here. They have to give you a form, and you have to show how your finances are, why you haven't been able to pay before they are even supposed to initiate any kind of arrest warrant. The trial court did not find that he was able to pay his arrearages, and nonetheless found him in contempt and sentenced him to 12 months imprisonment. So those are all of that's how his due process rights were violated. So here's, again, examples of safeguards that you can take back to the local agencies if you can't afford to pay your arrearage and the support for whatever reason. You got sick, you lost your job, you're homeless. There's all these different reasons before they can lock you up. So the child support representative must provide the opportunity of the contempt hearing, for the non-custodial parent to respond to statements and questions about financial status. Requires an express finding by the judge and that the non-custodial parent has the ability to pay based on facts in the case. You have to look at every case individually, and they have to determine that, okay, you have a job, you have all this money, and you are refusing to pay. That's the only way that you're breaking the law, where it will require that you go to jail for contempt of court. Anything else is a violation of your rights. If you're sitting with $1 million in a Swiss bank account, hiding money, and you got this mansion, and your kids are over there living in squalor, and you're, living up, well, yeah, that's what they mean by this. Everything else they're doing it pisses me off. Okay, states should consider whether procedures employed in states' contempt practice are fundamentally fair. Safeguards implemented to reduce risks of erroneous decision-making with respect to the non-custodial parent's ability to pay. It's all about ability to pay. The willfulness to pay, the willfulness to not pay is how you violate a child support order. Okay, I know I'm probably repeating myself, and it's because it's repetitive, and because that's the guidelines. If you're not willfully failing to pay, you're not breaking any law. So they shouldn't be locking you up. And this is a side note, but I say this to people that maybe are not affected by child support right now or don't have any children. They are the return of debtors prison, which were outlawed in 1833. Let me see, denied equal access rights, extort money from me. Yeah. I'm sorry. So when they started this child support, locking people up, they can't pay this child support, and everybody's all gung-ho. Yeah, lock the deadbeat up, quote unquote. Take care. You don't take care of your kids. And I'll say this every time, nobody from my organization, and I don't think anybody from many organizations have ever said or condoned a parent not taking care of their child. That's never been the case. This is about our rights being violated based on an ability to pay. Debtors' prisons are returning where it's a crime for you to be poor or not able to pay for certain things, a ticket or whatever. So it's going beyond even child support. So people that say, oh, it's not their problem, or they don't want to get involved, or they don't understand why we fight so hard, this affects everybody. My children are adults now, but they will hope, if they want to, one day have children, or they might get a ticket. They might not be able to pay that ticket. It's not a crime, and it should not be a crime to be poor. And that's where we're going back to. And that's what A.G. Sessions, when he rescinded that letter, that's basically what he did. He said, you know what? It's a crime to be poor. And I have a big problem with that. And everybody should, because I don't know any rich people. I don't know if y'all do, but I don't, except on TV. Okay, so I just had to say that. That's been on my mind. I haven't been active. I've been sick. So, okay, so the Supreme Court held that the court may not impose punishment in a civil contempt proceeding when it is clearly established that the alleged contemptor is unable to comply with the order. If they can't comply with the order, they are not breaking the law. Okay, so the civil contempt statutes require that the underlying order be willfully and intentionally violated. Willfully and intentionally violated. Okay, so we have child support agencies. This is what these agencies are supposed to be doing. So if you have a case and you're going back and forth with the local agency, you might have to educate them, because they're just going by whatever, and they're violating your rights. So, and send them the link, what's your email address, stay on them. You have a right. They work for us. They're government employees. They're our employees. So they need to be following these guidelines. Like I said, I can't say the law because they break the law every day enforcing this child support crap. Okay, so child support agency should re-examine, and this is from the Federal Child Support Enforcement Agency. This is from their assessment of the Turner versus Rogers ruling. And like I said, my slides will have, I have the link on there. So child support agencies should re-examine state and local policies to ensure that non-custodial parents are afforded sufficient due process protections. Cases should be individually reviewed. The individual review should examine actual and present ability to comply. Okay, B, notice should be provided to the obligor that ability to pay is a critical issue in the contempt proceedings. They have to notify you. Judicial procedures should provide an opportunity to be heard on the issue of ability to pay and result in express court findings. This is notated and it's bold. Having the opportunity to be heard is the foundation of due, whether you are talking about your child support case or whatever else your case is. You have a right to be heard, especially when you can go to jail and be imprisoned because somebody is accusing you of something. And in these child support cases, somebody's accusing you of not taking care of your child. So they sue you for child support. So this is what I tell these young parents. If you are providing for your child, keep receipts. If you don't give cash ever, keep receipts, document everything. And if the other parent sues you for child support, you go and show them, I take care of my child. I provide for my child. They have to prove, they have the burden of proof to prove that you don't provide for your child. And when they prove that you don't, okay, now they have a child support order to force you to pay child support. If you prove, hey, I take care of my child, I pay for my child, then they won't have a right, they don't have a right to even order you to pay child support. You're already doing that. But that's another topic for another day. But you young parents out there, just know that this is a voluntary program. Unless you receive welfare, then they mandate that you sue the non-custodial parent for child support. But I digress. Okay, so the purge amount should take into account the non-custodial parent's substantive needs of the non-custodial parent. And this should be based on written findings that the non-custodial parent has the actual ability to pay from the current income and assets. All actual. That imputed income that they do when they do default judgments, what do they call it? Dad by default. And they just say, oh, based on Joe being a 25-year-old male, he's supposed to be making $15 an hour, and they impute this income. Well, if Joe has a felony, he's not making $15 an hour. But that child support order is going to be based on him making that amount of money. That's an imputed income. That's not how they're supposed to calculate child support based on your due process in Turner versus Rogers, your due process rights. Okay, so using contempt in child support cases in which ability to comply. Using contempt in child support cases in which ability to comply is the issue. Okay, so this is referencing like forcing parents to participate in jobs programs or drug rehabs as a condition instead of sending them to jail. So they're saying they're supposed to offer some type of program to help in lieu of sending a parent to jail. So if your local agency is not offering you any programs, do they have any jobs programs, anything like that to offer to help you make money, then they're in violation of the law. They're supposed to offer that before they send you to jail. So that's all I have on this topic. I hope for anybody that tuned in, I hope it was helpful. Like I said, I prepared some slides that I'm going to post on here. I don't know how to post while I'm live, so after I stop the live, I'll post them on there. It's about 7 slides, and everything I went over is on there. And there's a link to this actual analysis that the Federal Child Support Agency put on their website. That's where I got this information from. And then there's also a link to programs. It's like a map that'll have all the programs that are offered across the nation for fathers, or I'm sorry, parents. They I think they say fathers, I'm not sure, but supposed to offer parents that need help finding a job. Let me see if I have any questions. Equal access, nice experiment for me. I'm gonna see if there's anybody that's gonna ask any questions while I'm on here. As always, I thank you guys for supporting the page and sharing the page and coming back and liking the material and everything like that. I really appreciate it. And I know we're getting some results. I'm seeing some laws being changed. I try to post when I see different articles, or if I see a state implementing a new law, I try to post it so you guys are aware of what's going on. Because knowledge is the key. They don't want you to know about this. They'll put everything out, but they didn't put this Turner versus Rogers out. You're welcome, Adam. Thanks for being here. Oh, hi, Chuck. I just went over Turner versus Rogers. I did some slides, so I'm going to post their in picture form, and it's going to have pretty much outlined everything I went over, and then the links of where I got the information from. And of course, you can message me if you have any questions or anything. Just was touching on this case since what's his name, AG. The AG rescinded the letter I talked about last time I was live. I don't know if you saw that or if you heard about it. He rescinded the letter, the due process. I have it with me. Somebody, thank you, whoever did that. Somebody posted the letter in one of my posts because you can't find it. The link is gone. About how they're supposed to honor, honor due process and everything with license suspensions and all that kind of stuff. So you're welcome, Jeremy. Thank you for tuning in and thank you for your support. That case is from South Carolina initially, but the Supreme Court, the United States Supreme Court, ended up ruling on it on June 20th, 2011. They really can't. Like, I don't, and I always say, as far as them taking money and things like that, I always said, if I ever see a case that, and I say, oh, okay, I see, I can understand that, or I see where that's legal. I haven't seen it yet. I haven't seen it yet. And it's going to really start affecting people when it starts spilling over to people that's not on child support. Like I said, they start arresting them for these credit card debt, cell phone bills, debt, and all this kind of stuff. That's when people will say, hey, oh, this must have been what they were talking about, debtors' prisons. Because with him rescinding that letter, that was a big deal. But I put a post up because they were on Twitter. They were pissed off about whatever he did about the weed, but they weren't mad about him rescinding that debtor's prison letter. Oh, it is nationwide. It's this is from the Supreme Court, Chuck. They should be doing this. They should have been doing this all along anyway, but they violate their own laws when they execute this child support system. Because really, if you don't willfully fail to pay, you're not breaking any laws. If you're unemployed and you're actively seeking employment and you get behind on child support, you didn't break a law. They shouldn't even suspend your license, and they shouldn't be locking you up. You should not be locked up. That is illegal. I'll be really happy when the ACLU or, the civil rights, somebody that has some power comes in and stops this mess. Because they're going to be knocking on, like I said earlier in the post, I don't know any rich people. Everybody I know is subject to hitting the curb. They missed a day, 6 months of work due to cancer or whatever. The mortgage can't get paid, or their car note can't get paid, and then what? Then they're going to see what's going on. I don't think anybody does, Chuck. I don't think anybody does. There is no statute of limitations, Jeremy. This is the law of the land. They should be doing this anyway. If you look at any statute from the federal level on down to every state, a person must willfully That's the key word. It's in air. I've looked it up. Willfully fail to pay child support. If they do not, if that's not the case, they're not breaking any law. Kelly, Kelly, that's these people that I can't even talk. I'm telling you, after somebody sent me that decision with when he rescinded that letter, Sessions, and it took the wind out of me. I was really upset. I had some people that talked to me, Nate, one of my supporters and friend of mine on here. Hey Nate, I don't know if he's still here, but I had some people talk to me because I felt really defeated. For the first time since I started this, I really felt like, dang, we really, I mean, there's nothing that we can do, but we can't stop now. We can't stop now. We got to keep on going. Hey, Todd. So, and I talked to my son. I said, I don't know, son. I think maybe I need to. He said, Mom, you can't stop. Can't give up. So I'm here. I'm back recharged, trying to recover from the flu. I got my notes out. So I said, okay, we're going to keep on going. I'm going to let's keep on going. So if y'all are fortunate enough to have a lawyer and you're fighting a child support contempt case, when I put these slides up, give him or her that information and let them take it to the judge and make them follow these rules, these guidelines. I can't call them laws. I can't call them laws. Just guidelines. Okay, so if there's no other questions for me, guys, like I said, I'll put the slides up. They'll be in picture form. I think you'll be able to download them. If you need them, I can probably email them to you as attachments if you want them, just to have them. I've been working on them this afternoon. My dad was waiting for dinner. I did not cook dinner. I was making these slides. So I've mentioned them a lot because I've been working on them for hours. So I'm gonna go in here and again, I thank you all for all your support. I hope that you're sending the letter out to your local, state, federal representatives. Media attention is always, I think, a good tool to use if you're being if your rights are being violated due to child support or any other. If you're involved in a debtor's prison or about to go to jail, you know, we really have to. I'm trying to find out who we contact in order about this letter, and so we can get the debtor's prison thing on the forefront. And they need to re-abolish this. It's back, and they did it through child support. So please check out our website, thechildsupporthustle.com. If you need any help with your case, you can send me a message, an email, cshustle1@gmail.com. I don't answer my phone much, so either message on here. I don't usually respond to the comments too much because I'm working, guys. I'm always trying to find out, you know, a way to combat this machine. It's a lot of work. So always looking for volunteers. If you want the book, you can download. We have the ebook. We have it in print. If you want the Child Support Hustle t-shirt, you can order it from our website. All proceeds go back into the movement for fighting for child support reform. And thank you all. Remember, they can ignore one, they can ignore hundreds, but they cannot ignore thousands. Let's go. Thanks, guys.